Hi, everybody. I'm Lynn St. Louis, and I am a estate planning elder law attorney. And if you're looking for estate planning 101, just the basics, you're in the right place. So hopefully that's what you're interested in hearing about today. My goal with this is to really present, basic information about estate planning, documents, how an estate plan works, and really try to simplify what is it that you need to know. So we're recording this today, and that means that if you want to review it later, you'll have an opportunity to. We're going to send you a link with this webinar in it, so you can refer back to it. And if you want to share it with anybody, feel free to do so. If you look at the bottom of your screen there, you'll see a little chat box. So feel free to ask questions as they pop into your head as we go through this. And at the end, I will answer all your questions. Also, if you would do me a favor, we always appreciate knowing how you learned of this webinar. So if you would include that in the chat box now, just go ahead and comment and say, all right, well, how did you hear about this? Was it through Facebook or from a friend, or how did you learn about it? If you do that, I'd really appreciate it. Thank you. All right, so I am going to share my screen here so that we can move forward with the presentation today. Estate Planning 101. It is definitely not a law school class that you would have, but it is going to give you a lot of good information. So I'm really excited that you're here and that you're going to be, learning quite a bit today. So, all right. A little bit about myself. I know some of you have attended these webinars in the past, so I'm not going to take very long on this. As you know, I'm a estate planning elder law attorney. I've been in practice since 1985. I'm the founder of Elder Law Group, and I have a number of awards. More than that, though, what I've done is I have served literally thousands of clients, helping them figure out their estate plan. But it's really not all about me. I've got a fantastic team that is a great group of people, and also have offices here in Spokane and in the Tri-Cities. So let's move on without further ado to estate planning basics. So I know some of you have listened before to the webinars, so some of it's going to be a refresher. Some of it's going to be new. So what we're going to cover today on just the basics of estate planning is durable powers of attorney. Those are the most important documents that you can have during your lifetime to protect you. More than any other document, it's durable powers of attorney. We're also going to be talking about healthcare directives. And that also is a document that protects you during your lifetime, because that's something that puts in writing what your end of life wishes are, which is pretty important. One other thing I forgot to mention, please stay until the end of this presentation, because I will have a pretty cool offer for people that stay to the end. Wills and revocable living trusts, those are basic fundamental estate planning documents. We're going to cover those today. And lastly, we're going to talk about something that's very much overlooked, which is assets, asset ownership, and asset direction. So that's the outline for what we're going to be talking about today. All right, let's start with what I call living documents, that being those that protect you during your lifetime. Financial durable powers of attorney, healthcare durable powers of attorney, and healthcare directives. So, financial durable power of attorney. What is it and how is it used? So, what a durable power of attorney is, it's a legal document that you sign where you name someone you trust to act on your behalf if you're not able to do so. And the person that you're naming is called your POA. POA or attorney in fact. So as a lawyer, the term I use is attorney in fact. But most people, when they say, that they're serving under a financial durable power of attorney, they'll say, I'm the POA, I'm the POA, I'm the power of attorney. And that works just fine as well. So commonly people call themselves a POA. A financial power of attorney is used, obviously, as it says, for finances. So what that means is, if you're not able to manage your own bank account, you can't pay your own bills or manage your investments, or what if your house have to be sold, or anything that you would commonly do that has to do with your money, that is what is covered. That's the authority that you grant under a financial power of attorney is going to give to the person you trust the ability to help you when you need that kind of help. So this is why I think that this is such an important document, is that it protects you in case something happens to you. If you're not able to manage your own affairs and you don't have a durable power of attorney in place, then what's going to happen is a guardianship. Now, why it's called durable is that the document stays in effect, and even if you no longer are able to, if you lose legal capacity, so if you had a stroke or dementia or, anything that would render you not able to take care of yourself, well, the durable power of attorney is going to remain in effect. And that's the purpose of it, so that somebody who you trust can step in and take care of things that need to be taken care of. So it protects against a guardianship, because if you don't have durable powers of attorney, what happens is that the state basically takes over. You become a ward of the state. Everything is managed through the court. You have a guardian appointed on your behalf, and that guardian may be somebody you have never met before. So it's really, besides it being in the courthouse and all the reports that have to be filed and it being expensive, on and on and on, if you've ever been involved in a guardianship, you know how intrusive it is into life. And sometimes people, you might be married. So if you have a spouse and you think, well, I'm married, therefore I get to manage my spouse's affairs, even if, he were to lose capacity. No, that's not the case. Even though you're married, think of it this way. Have you ever tried to, have you sold a house or bought a house? Requires both of your signatures. So you need to have a durable power of attorney, because without it, you can't sell your house because your spouse is incapacitated. So that means without a durable power of attorney, you're dealing with a guardianship, even though you yourself are perfectly capable, but because your spouse isn't, the court is involved in all of your business. So I can't stress enough how important the durable power of attorney is. And just think about that. I mean, if you had to sell your house and your spouse is incapacitated, do you really want the court being involved in every single thing you do? Obviously the answer is no, you don't. So the power of attorney, the durable power of attorney for finances and the durable power of a health care, which we're going to talk about next, that ensures that you and the person you designate will be handling whatever needs to be handled in your life without the intrusion of the court or the state. So it's really important. So the healthcare or the medical durable power of attorney, just like a financial power of attorney, what it is, it's the legal document where you name somebody you trust who will speak for you if you can't. And under this document, it'll be the person you designate can be called your POA, but usually they're called the healthcare agent. or I've abbreviated it here, HCA, the healthcare agent. So when you fill out a power of attorney, be it financial or medical, when you sign it, you're called the principal because you're the one that signs the document. The person you designate is your agent, your POA, or your healthcare agent, and they're the one, the person you've designated who speaks on your behalf if you're not able to do so. So you can have a financial power of attorney that's separate. The document can be separate from a healthcare power of attorney, or you could have it all combined into one document. We at Elder Law Group like to have them separated out. The reason for that is that we know that it works better, and so part of why we do what we do and how we do it is because we know what works the best. It's easier to have a financial power of attorney. You give that to your bank, have your healthcare power of attorney, that goes to your doctor. But there's really nothing wrong with it being a combined one. We just try to draft what's the most effective for our clients. So the healthcare agent, that's the person who's going to be under the medical power of attorney that's going to be talking to your doctors if you are in the hospital, in surgery, something like that. So the biggest question when it comes to, well, who do you designate? You should designate the person who is very trustworthy. So it's somebody who is responsible, somebody who's capable. Often it's a family member. It could be your spouse, it could be an adult child, it could be a brother, a sister, a cousin. You know, it should be someone who knows you very well. If you don't have a person who knows you very well, you just don't have those options, you can name a friend, or there's even professionals who will serve as a financial power of attorney or as a healthcare power of attorney. And so we do have, when clients don't know who they should name, we can give them some suggestions. You do want to name more than one person. We want to have, you know, perhaps like your spouse is in the first position, and then after that, if your spouse can't serve, we want to have somebody else who's designated, for example, an adult child, and then maybe after that, another adult child. So you don't want there just to be one person named in your document. You have to have successor order. And the reason for that is, you know, if you're married, you and your spouse might travel together and something might happen to both of you. So you always need to have a backup. What we do with estate planning is we're always going through like, well, what if this happens? What if that happens? And so that's the reason that we suggest that there be successor agents named. One of the things, though, you really want to be careful of is do not name co-agents. Co-agents, if you name them, are they going to agree? Are they going to both, you know, sometimes I've had people say, well, I want to name all three of my kids to help me make decisions for me if they're in the hospital. And the person might say, the client might say, well, because I want them all to talk and I want them all to be involved and know what's going on with my health care. And of course, that's totally understandable. Of course, you would want your kids all involved, but it makes it really difficult for the doctors to say, okay, well, who am I supposed to be taking direction from? So we really want to name just one person and let them all talk, but then have a spokesman for that group. So just name one person. Don't do co-agents. It can really result in problems. Imagine if there isn't an agreement. Well, if there is not an agreement as to the decision that, you know, on whatever the co-agents have to make, then it's just like not having a power of attorney. What that means is then it goes into a court-ordered guardianship, and that was a situation you were trying to avoid in the first place, not having the court involved in your affairs. So co-agency is really not a good idea. All right, so let's talk about HIPAA. I'm sure everybody, every time you go to the doctor's office, they have a HIPAA form you fill out. HIPAA is medical privacy laws. So it's intended to make sure that your personal information is kept private. Totally makes sense. But keep in mind that the person you've designated under your financial power of attorney, they might need access to your medical records. What if they have to deal with your medical insurance company? Your healthcare agent, obviously they need access to your medical records because they need to know what's going on with your healthcare. So any durable power of attorney should have in it a HIPAA authorization. So that's something that you want to make sure of if you have a power of attorney, that it contain HIPAA language. If not, if it doesn't have HIPAA language, then the person you've designated under your durable powers of attorney, they might have a difficult time doing their job. And the whole, one of the purposes of having good durable powers of attorney is that they can do what they have to do and not have to fight to get information or to get the documents accepted, that sort of thing. All right, durable powers of attorney. That's what I was most passionate about talking about. Healthcare directives, though, are pretty darn important too. So we call them, in Washington State, we call them healthcare directives. They're known as advance directives. They're also known as living wills, though it has nothing to do with a will as you normally think of a will. But they all mean the same thing, so I wanted to make sure I shared with you that information. So what is it? It's the legal document which states your end of life wishes. And basically what we think of is, well, what kind of care would you want when you are at end of life? Or what kind of care would you not want? So most of the time when I meet with clients, they often say, no, I don't want heroic measures. So people often know what they do want. They know that they don't want heroic measures. But the thing is that it's really important to put it in writing, because if you don't have it in writing, I actually have something here. It says, if it's important, put it in writing. It's got to be in writing for several reasons. Number one, that way the doctors see it. They know what your wishes were, if it's no heroic measures. Number two, by having it in writing, you're actually alleviating some guilt that your healthcare agent might have if what they have to tell the doctor is, for example, pull the plug. So it's helpful for your healthcare agent to see what your wishes are in writing. Now, a lot of times people go, well, I want medical treatment until it's going to be futile and it's not going to do any good. So what's important to understand with the healthcare directive is that it does not come into play until your doctors, so either an attending physician or two physicians, put it in writing that you are in a terminal or permanent vegetative condition, and that any further treatment is really not going to be beneficial to you. It's not going to make you any better. So a healthcare directive truly is an end-of-life document. So just because you sign a healthcare directive that says no heroic measures doesn't mean that, like, let's say you write to clients, it's like, if your heart stops beating, you stop breathing, we're calling 911 and they're going to come and they're going to resuscitate you despite your healthcare directive, because no doctor has declared you to be in a permanent vegetative condition. So really, it's that document that is intended for end of life, not until from here to there, but end of life. If you don't want heroic measures, a healthcare directive is what you say. We put our healthcare directive, we combine it with our healthcare power of attorney, we put it into one document. The reason that we do that is that they really go together. I mean, who is speaking for you and what are your wishes? We feel that that works best in one document. They don't have to be combined. Again, it's just that what we have found works better for folks. But a lot of people have their healthcare directive separate from their healthcare or financial power of attorney. There is a different, I don't have a slide on this, but there is a different form called a post form, and this is really not an estate planning document. If you know what I'm talking about, it's that lime green form, Physician's Order on Life-Sustaining Treatment. And that's also referred to as like a DNR document. That is really intended for emergency responders. If you know that you don't want resuscitation efforts, should you stop breathing, then that DNR pulse form is what you would get from your doctor, not from a lawyer. And of course, you post it conspicuously, so that usually means on your refrigerator. But that is a different document than your healthcare directive. One does not substitute for the other. And that kind of leads me to the next thing, is that sometimes people go, well, I have a healthcare directive. Do I need a durable power of attorney? It's like, yes, you actually definitely need both. The healthcare durable power of attorney says who speaks for you, and the healthcare directive says what your end of life wishes are. So you need durable powers of attorney that addresses finances and health, and a healthcare directive. Those are the key fundamental estate planning documents that you need to have in place to protect you during your lifetime. So we're going to move on to other estate planning documents, including a will. So we've all heard of a will. A will is a legal document that says who gets your assets, when you're gone, and it only takes effect upon your death. So it doesn't have any effect while you're alive. A will should accomplish more than just who gets your assets. For example, a will can be used to name a guardian for any minor children. So we want to make sure that we avoid, if there's a minor involved, we really want to make sure that there's not going to be disagreement if both parents are killed and there's a minor child, who's going to parent that minor child. It really needs to be put in the will of the person who passed away that they nominate, you know, their sister or you know, someone to be the guardian for the kids. And that way, then the court is going to respect what was said and likely will appoint who was nominated. Wills also can contain an asset protection trust. The last webinar I did was on asset protection, so we're not going to take a whole lot of time. We're just hitting the basics today. But what I want to make sure that you're aware of is that a will with asset protection is a way to make sure that when you or your spouse passes away, that assets, you know, their share of the estate can be protected for your benefit, so that the state can't get it, creditors can't get it, it doesn't interfere with benefits for long-term care. It really is an excellent way to protect your spouse, but any beneficiary. So, you know, we want to make sure that if you have a minor child, that there's going to be a trust for the minor. If you have grandchildren, maybe, you know, your will should have a trust for the grandkids. If you have a beneficiary who is on government benefits, there should be an asset protection trust in the will for that person. And even if they're not on any kind of benefits, but their lifestyle is such that you're concerned about them inheriting money, that it might, you know, be wasted, or a divorcing spouse could get it. You know, you can just imagine all the possibilities. A will can protect any beneficiary. So upon your death, your assets then can go through your will to a trust for a beneficiary. So, you know, most wills do not have asset protection trusts in them. Usually it's an elder law attorney that would be preparing that kind of a document. And the reason for that is that as an elder law attorney, we have knowledge about what the government benefit rules are. And so it's for that reason our estate planning documents are going to contain protections that you won't find in really a traditional estate planning attorney's wills. So I just want you to keep that in mind. Again, we're not covering asset protection trusts in detail today. All right, so let's move to revocable living trusts. I'm sure most of you have heard of them. I know whenever I turn on different, shows on, public TV, you might see somebody like Susie Orman, a financial advisor, or somebody like that saying, you must have a revocable living trust. So let me explain what they are and how they're used. So what it is, it's a legal document. Obviously, it's an estate planning document, and what it's intended to do is to manage assets and to pass assets upon a death. So if you have a revocable living trust, you sign it, you create it while you're alive, and then you usually are the what's called the trustee. The trustee is the person who manages the trust, and you are the funder of the trust, which means you put your house in the trust. You do a deed to the trust. Your bank accounts go in the trust. You have to retitle them. And so you fund the trust, you manage the trust, and you're the beneficiary of the trust, meaning you take all the assets out of the trust as you want to. So you're the beneficiary. So you have total control over the trust when you have a revocable living trust. So that really is one of the reasons that leads to some confusion, because a revocable living trust is in effect while you're alive, but it really doesn't seem any different than when you didn't have a trust. And it's for that reason that people really get confused about a trust. There are benefits to a trust, and then there are some downsides to the trust. So a benefit, one of the main benefits to this, having a revocable living trust, is that if you can't manage your assets, then the assets should be in the trust, and the successor trustee, the person you've designated to be the next trustee after you, they can manage them for you. Now, that's the same role that somebody you've designated under your financial power of attorney would do. They also would be managing your assets. And if you do have a revocable living trust, you also will have a durable power of attorney. So that's one of the reasons to have a revocable living trust, but it's not the compelling one. The reason that most folks are interested in having a revocable living trust is that they've heard that they avoid probate. And if all of the assets are in the trust as they should be, retitled into the name of the trust, then yes, it can be successful to avoid a probate. One of the problems with having a revocable living trust, though, is there is complexity to it. You have to have an understanding of it. So if you have one, make sure your attorney sits down with you and explains, how does this work and why do I have this? Because, you know, any kind of an estate plan, the reason that it works is that you understand it. When I started practice back in 1985, I started as a litigation attorney, and I didn't become an elder law attorney until my parents started needing care, and that was back around 2002. And I think it was because I started out as a lawyer that wasn't estate planning, but was a litigator. It was really important for me to understand how estate plans work and be able to convey that information to my clients in a way that they could understand it too, because I saw that if people don't understand what they have, then their estate plan isn't going to work for them. So I really encourage you, if you have a revocable living trust, make sure you understand it, and don't feel bad if you don't understand it. Believe me, they aren't that commonsensical. So talk to your lawyer. You know, if whoever drafted it for you, give them a call, say, hey, I really want to talk about how does this work? And also, you know, there are downsides to a revocable living trust. The major downside to it is if you are married, a revocable living trust cannot protect assets for your spouse when you're gone against long-term care costs. The rules in our state in Washington are really clear. The only way to do that is if you do it through a will and not through a revocable living trust. So if you have a revocable living trust, you might be concerned. It's like, well, I thought this was going to protect money for my spouse when I'm gone, and they'd qualify for Medicaid and their long-term care would be paid for, and all of our money wouldn't be going to long-term care. And yet you have a revocable living trust. So what I'm saying is that having a revocable living trust does not protect your spouse when you're gone against long-term care costs. So go back to the attorney that drafted a trust for you and have that conversation. Another problem with a revocable living trust, especially if it's not well understood, is that you have to have all your assets in it, but you can't have all your assets in it. You can't have your 401k or your IRA put in your revocable living trust. So it's important that you understand what can be in a trust and what is not in a trust. And if it's not in the trust, then what are you supposed to do with them? How do you coordinate that with your estate plan, with where you want your assets to go? So let's talk about that next. So the downsides, so there are benefits, there can be benefits of a revocable living trust. It's a little bit more complex having a revocable living trust than not, but there are definitely downsides of a revocable living trust. So I want to talk about non-probate assets, because non-probate assets are assets that usually aren't in your revocable living trust, and they're not covered by your will. So, all right, so this is adding a little bit more complexity. It's like, well, I thought my will would cover everything, or my trust would cover everything. It's like, no, they don't. So important to understand is what is not governed by your will, what's not governed by a revocable living trust. Your life insurance policy is not covered by the direction of your will or your trust. So just think about this. When if you have a life insurance policy, they asked you, well, who's going to be the beneficiary of the death proceeds? And you filled out a form. That's called a beneficiary designation. And that says where your life insurance goes on your death. You don't want it to be silent. You do not want it to pay to your estate. You want it to pay to a person. Similarly, your retirement accounts like a 401k or IRA, those all should have a beneficiary designation on those as well. So that's something that you really want to check. Make sure that it has the right person on it. Sometimes people get divorced, and we tell people, review your estate plan every 5 years or so. Sometimes people get divorced and maybe through their work they had a 401k and their ex-spouse is named on the beneficiary designation. And they're thinking, well, they're my ex-spouse. They're not going to get the 401k, are they? Yes, they are, because there's different rules that apply, federal law, it's called ERISA, that applies to your 401k. And if you have your ex-spouse named on it, been divorced 10 years or more, they would get your retirement account, which is really something shocking to people. And sometimes their retirement account's their biggest asset, so they sure don't want their ex-spouse to get it. So really important to understand who is on your beneficiary designation. Other non-probate assets, that would include a bank account, for example. You might have a bank account where you say, on my death, my bank account pays to someone. Bank account is going to pay to that person that you said it goes to. It's not going to go under your will. Also, you might have a bank account that you have, maybe you put one of your adult children on your bank account just for ease of management, and you put them on as joint tenants with right of survivorship. That's fine if it's a small account, but the problem with it being a large account is that if you have a bank account that upon your death goes to maybe one of your children and you've got 3 kids, that surviving child is the owner of the account. And if you said, well, I put you on it just so that you could manage my assets, they actually are the legal owner upon your death. And they may decide to divvy it up with their siblings, or they might not. They might say, no, Mom really intended me to have this account. So that leads to a lot of family conflict, could lead to litigation depending on the size of the account. So it's important that you understand the consequences of when you put somebody on a bank account with you. There could be a problem with that. And also, I do want to point out that if you put a child's name on an account with you, if any creditor comes after that child for, maybe they're in a car accident, or maybe they have debts or something, and it's your money, but you put your kid's name on the account, that creditor will try to take away the money that's your money, that's in your account. And the reason that the creditor has an ability to claim that is that you put your kid's name on the account. So that's really not the best way to set up an estate plan. Okay, so I told you that this would be basics, and that's all I wanted to cover today. I always want to leave you with a message that just by having an understanding, we're empowering you with enough knowledge that you know that you can take steps to protect yourself, protect your family, and protect your money. And I think we all agree that's just the cutest little kid picture ever. All right, well, thanks everybody for joining. And again, reach out to us if you have any questions, and we'd be happy to answer them. Share the link when you get the link for this webinar, and I appreciate you coming. Thanks so much, everybody.